In the last lecture, I was concentrating on the Adam Smith's invisible hand. The idea, which is first found in Bernard Mandeville's Fable of the Bees, published in 1714, a book which has as a subtitle, Private Vices, Public Benefits. The idea that by following a very self-centered purpose, individuals do actually contribute to the common good, and in Mandeville's in particular, that they do so better, that they were aiming deliberately to the for the common good by being virtuous. And that therefore the kind of scandalous assertion of Mandeville that it is by being vicious, by having private vices, that people contribute to the benefit of the whole society. This is, of course, counterintuitive, because the view until then was that it was by being virtuous that people contribute to the common good. And what happened in 2007, 2008, there was a switch back to thinking that traditional view, that it is by being virtuous that we help the common good being achieved, that we help at the working of society as a whole. What I tried to do at the end of the lecture was to show that if that view is correct, that there's an invisible hand operating in society, it does not operate all the time. And I gave a few examples of things that gone very, very bad, in particular during the beginning of the crisis. And I gave as an example a policy that had been adopted by the American investment bank, Goldman Sachs, where it did produce deliberately a security, a debt instrument of the worst possible quality, without informing that it would be the case, its clients, and betting that the value of that product would depreciate, while trying to have counterparts that it would actually trust the company that it was a product of good quality. When I finished, there was a lawyer in the audience who came to me and said, "This is fraud. This is actually fraud." And I said, well, I mean, that might be your opinion, but it is definitely not the opinion of the Department of Justice in the United States, who, after a long investigation, having called people to testify through hearings, the heads of the company, the executives of the company, had decided that there was nothing actually to justifying that they would be taken to justice. And that person saying, well, this is definitely not the case, but it is the case. And why is it? There's a person there's a lawyer in France called William Bourdon, whose view is that we don't have currently, law has not defined either felonies or crimes in such a way that indeed such behavior would be regarded as being illegal and would lead to prosecution. This is something that the leaders of the heads of Goldman Sachs knew in the days ahead of the hearing at the American Senate. Mr. Blankfein, Mr. Lord Blankfein, who is the CEO, the head of the company, was declaring that he was a market maker, and a market maker is just somebody who, in the market, is prepared to buy and to sell. And his argument was that he was prepared to buy and to sell at a particular price that he would set, but also be prepared to negotiate with his clients. And if his clients decided that the product was of poor quality, they had just tried to haggle and haggle in order to lower the price, and that would be it. And indeed, during the senatorial hearing, that was the policy he adopted. He said that he was dealing the counterparts he had in the operations of Goldman Sachs, where people were sophisticated, which is the expression, the phrase which is used in the United States. They were sophisticated. They knew what they were doing, and for that reason, there was no there was no fraud. And apparently I mean, his view was adopted because he has never been prosecuted. So some people, of course, have an alternative view. There's the phrase revolving door. Revolving door means that people from Goldman Sachs, it's well known, work sometimes in the administration, sometimes they're back in the banking business, and then they go back again to working at the higher ranks of the administration. And therefore, the phrase being used for that is, you may have heard it, crony capitalism. You will not want to prosecute somebody who is an old friend from school. I mean, if somebody who was very close to you, you will not go to justice and put these people to jail. The alternative, of course, is that notion that there is no proper definition for that attitude as being a crime or a felony or any other type of infraction to the law. And this leads us to, I would say, to a very interesting introduction to the lecture today. The first thing we have to address is indeed a breach in the law. Somebody behaves in a way which is not allowed by the law. And in business and in finance, we call that fraud. And a good example of fraud in recent years is the one of Mr. Bernard Madoff, who built a fund where he would promise to actually pay a dividend of about 1% per month, which amounts to something in the region of 12%. And a lot of people went into his fund, and it turned out that his fund was actually a pyramid, or what is called now a Ponzi scheme. And this is how would I say, this is a construction where, as you know, people are asked to come and contribute, and they really, most of the time, they're told that there will be a very high reward for joining. And what is happening is there's no actual business behind it. The only thing which happens is that the people who have come first are being paid by the contributions of the membership of the people who are coming later. In order for a scheme of that type to work, of course, you need to have a constant flow of people coming in. When, for some reason, you cannot find more people, like let's say in the subprime business in the United States, when you've given loans to buy a house to people who are increasingly poor, there's one point where you cannot go lower. I mean, you can't find people lower than the poor, and you don't have recruitment anymore, and you don't get these fees paid by the people who are coming in that would allow the older participants to be rewarded. What is interesting is that when awareness of that appeared in the subprime business, there was an interesting speech by Mr. Greenspan, the head of the central bank in the United States, the Federal Reserve. He gave a paper where he mentioned, it was hardly noticed because it was the very end of his long speech, but he mentioned that he was aware of the pyramid nature of the subprime business because he said it is important now to support residential real estate, that we get some new people in the United States in order to buy houses. And he became very specific. He said that there are some people who are working already for the United States from home, like the people who answer they do telemarketing, and or are people who are dealing with any difficulty you would have with a product, and you would call the company. And all these people, a large majority in those years, 2006, were Indians, people from India. And the same applied to for people who were in software and writing software. There was a large quantity of software writers who were in India. Personally, at the time I was at Countrywide, I was leading a team of eight software people. And 2 were in California with me, but the 6 others were indeed in India. What Madoff did, just a word about what he did, is that he didn't start his company, his funds, as being a pyramid. It is a somewhat tragic story because he had actually a business. He was actually producing the returns that he was giving to his clients in the beginning. He had found a way of doing it. And I won't go into details. It was something, an option combination called collars, and he was indeed doing that. But then more and more people wanted to be in his fund. And instead of saying, well, I cannot go above a particular size of my business, because having more people joining would actually unbalance the market, and it would make it impossible to keep on doing that. There's a size of the markets on which he was operating that was a restriction to the size it would be able to work. And instead of saying that, he went on and starting pretending. But the people who were joining his fund would, on a regular basis, receive the operations which were the ones supposed, a statement about the operations, which were the ones he was supposed to do, and which were the same as he had done in the beginning when the formula was working. There's nothing very specific to the crisis within which we are. The fact that Mr. Madoff was doing this pyramid scheme, this is a very old trick. Mr. Ponzi himself was somebody who was actually active in the 1910s in the United States. So there's nothing special for that. The fact that the fund collapsed was due to the fact that in 2008, a number of people got losses and had to withdraw money they had put in the Madoff fund, and that's what revealed the way it was working. So fraud is the first category, and we could go into a lot of detail about fraud, and I will mention some other cases of fraud during the lectures. There's another type of approach which is not illegal, which is the following. Just imagine that you have a great scheme, but in order to perform it, financial scheme, but in order to perform it, you would have to commit fraud. So what are the possibilities? Well, you can abstain, you can stay within the law. But we've seen in recent years a number of examples where what people did instead, because they had actually the wealth that made it possible, they lobbied in order to change the law before they would actually enter into the business. There are a number which are well known. There's a lot of talk currently of trying to introduce in Europe or reinstate in the United States something that was called the GlassSteagall Act. And the GlassSteagall Act dates from 1933. And it was a measure that was taken by the first Franklin Delano Roosevelt administration in order to separate speculation from the other activities of banks. It was realized that in the period leading to 1929, the big crash on the markets, the banks were speculating with the money that people simply had on deposit accounts in the banks. So there came something, there was an act, which is an act actually is a set of laws put together called GlassSteagall from the people who had actually proposed it, and that was voted and became law in 1933. In 1999, it was abrogated. It was abrogated after consistent move by Mr. Robert Rubin, who was the Secretary of the Treasury, which is the Minister of Finance of the United States. He worked along with Mr. Lawrence Summers, who was until recently a top advisor of Mr. Obama, to have that law, the act, being removed. It turned out that as soon as it was removed, he was appointed to Citigroup, where he became finally the CEO and made a benefit that was mentioned in the papers of $126 million in the operation. But the fact is that we know now that there was lobbying from Citigroup, because Citigroup, which is a banking business, wanted to merge with Travelers, an insurance company. And so it turned out that as soon as the act was abrogated that allowed that merger, Mr. Rubin moved to the company which he had actually helped by introducing that measure. There's nothing, and I was about to say unfortunately, but there's nothing illegal in doing that. These people are even regarded, I've seen in literature, as being people have been smart in doing that move. There's another example in recent years. What's her first name? Wendy Graham. Wendy Graham is an American senator, and she worked actively to remove the regulation of the energy business in the United States. And as soon as that she had managed to remove these laws about the regulation of the energy sector in the United States, she joined the Enron company, which was about to benefit right away from that suppression of the abrogation of the existing law. So this is a how would I say, it's one possible approach that prevents you from doing anything illegal if you have the money that allows you the amount of lobbying which is necessary to do that. There's an example that I'm checking whether I was right in what I was saying. I found an interesting example on Wikipedia of a company, no, it's not a company, it's actually a professional professional organization of the sugar business in the United States, which was very active to lobby to prevent that some subsidies were removed from the sugar industry. And they managed to prevent that, and by comparing, the author of the article, a person called Stewart, calculated that although the lobbying had been very expensive in terms of millions of dollars to do it, actually the return in terms of how much people, the consumers, would pay for sugar made that the return was 1 to 1,000. So the industry made 1,000 more time money than the amount that had been put in lobbying. And he had calculated also, Stern, that it was on average for an American household, an average of $71. It was in 1986, so it's not like $71 now, which he said is the amount of corresponding like a small tax on households. Another possible approach is is to work ahead when you know that new legislation is coming up. You may intervene to lobby to prevent it to being instated. If it would be detrimental to your business. The last time there was a question at the very end, and I gave very quickly some examples, but I will repeat them because there are very recent three very interesting examples that happened recently. One is from the month of August, and two are from the month of September, so they are very, very recent. The first one from August is one where the money markets, and I'll skip that very quickly because I mentioned it last time. The money markets, which is the short-term capital markets, managed to prevent any legislation of their business, although there had been 5 years of work in order to try to prevent the collapse, the meltdown that took place in October, around the 16th to the 22nd of September of 2008. Another example that's from September, the oil markets preventing any legislation to try to stabilize their market, which is very volatile for obvious reasons, as you know, and managed to veto the legislation. And I think I mentioned that the most probably, how would I say, distressing part of that is that there's the International Energy Agency was part of the people who vetoed the measure. When I say veto, actually, that's not a term I should use. What they said, that if there was new legislation to try to curb some of their practices, they would simply refuse to transmit the evidence, the price movements, and therefore there was no regulation would be possible. Another successful lobbying also in September was that there's been an attempt from the CFTC, Commodities and Futures Commission, I don't remember the T, that was, Trade, Commodities and Futures Trading Commission? That doesn't sound, we'll find out. Anyway, they had come up with measures in order to cap, to some extent, speculation, because, of course, as you know, speculative prices take prices everywhere, and it can be very detrimental. I won't go into an example, but the speculative prices can go very high, and then they just hit the consumer, or they can go very, very low. In that case, I mean, they may kill the producer, because you go beyond cost as far as the producer is concerned. And in this case, the industry, some of the speculators managed to, through a court injunction, stop the measures. And there's been a demand towards President Obama that he would take an executive order and try to rule over the decision by the court. The American system of courts is something I haven't totally understood yet, where you can go to any court anywhere, apparently, I mean, as far as I understand, and just try to sue the government for measures or governmental bodies for things they're trying to do. So I've talked about fraud. I've talked about, deregulation for a definite purpose. There might be good reasons for deregulation. There might be some rules which are constraining too much a particular market. But I've talked here of deregulation measures of a particular type, which are those whose the aim of which is definitely to prevent somebody who would have been a fraudster otherwise to have some laws removed in order for him to or her to behave the way they intended anyway. Deregulation, preventing measures from new measures from being applied, and so on. But then there's I would say a whole domain which is less obvious, but where there is, and there's been, I mean, the courts are filled with cases linked to that, which is not really fraud, but playing on contradictions within the existing system. The most obvious is what's called loophole. A loophole is actually a flaw in the law. Typical example is that there's a new law coming in, and there's no realization that actually that new law in some way or other is in contradiction with, there's a contradiction between that new law and some existing things. Or there's a number of cases are actually not being taken into account. And a typical thing that happens, and I don't want to be how would I say, naughty towards lawyers, because I see some in the audience here. But it happens typically in the big businesses that when there's a new law coming out, there's a cell being built right away with lawyers to find out how to turn the law, to find ways to not being that law would not really apply. A domain in which I was about to say I was lucky to work, but that's not lucky. That I did work is, for instance, about the extra compensation for executives in company, or extra retirement plans for executives of company. And typically, these would be built on loopholes in the law. You would find a way to turn the spirit of the law and find a way to, how would I say, to exploit it to your benefit. When I started asking too many questions in the business I was working in, they terminated my contribution to the company. A very well-known one, because the public became aware of it, because Roger Moore, the man who makes films, documentaries. I think it's Roger Moore, right? No? Michael Moore, exactly. That's because one of his movies, Looking for Roger, yeah, right, exactly. Michael Moore spoke about one of these cases where some loopholes were found in order to pay for golden parachutes and extra retirement plans for executives. It's the name, I mean, the janitor, yeah, the janitor insurance. What is a janitor? A janitor is typically some person who looks after buildings, stays there at night, maybe washing or cleaning the place from time to time and so on. And it was called the janitor insurance. Actually, the actual name is COLI. I'll try to remember the acronym, but it doesn't matter. The idea was that you insure for life somebody without telling that person. And so that person doesn't get the benefit of, the family of that person doesn't get the benefit of that person dying. It is the company that's employing that person and not telling even that person that there's a life insurance has been taken for on that person. Why was that regarded as so such an interesting loophole? It's because the classical view is that these payments that are made to people who are at a loss, or people are grieving because somebody has died in their company, you will not hit these people by high taxation, and therefore there's a fiscal interest to benefiting from these policies. Of course, if you don't tell the person, you've insured that person for life. There's no grieving, nobody's been bereft, nobody's being sad. The company is simply happy that there's more money that can be put on the retirement order, the golden parachute of the head of the company. The first time these were introduced, actually, I would say there was some logic, some rational logic. It was the idea that the company may be really damaged by the loss of one of its main executives, and that therefore there would be a justification of taking a life insurance on that person because of the loss to the company as a whole, because of the talent of that person as being a supervisory person in the company. When you started doing, not telling people. The law has changed. I think it was in 2006. The law has changed in the United States. So it's not that it's forbidden to do that, but you have to at least to tell the company that to tell the family that you have a life insurance on somebody. And then it became like, I would say, traditional, classical, that there would be some of the money being received by the company that pays the premiums to the family. So that's a typical loophole. Another way of taking advantage of contradictions is, of course, between fiscal systems. The Enron company that collapsed in 2001 was a company that had found a way really to work fiscal arbitrage. They call it arbitrage or optimization, meaning that if you can define something so that it's not exactly within it doesn't fall anymore in the taxation system that was supposed for it, if you can redefine it in order to be able to put it in a different type of to depend on a different type of article of the fiscal law where the taxation would be lower, you do that. Among the most funny examples of what Enron did was synthetic loans. Synthetic loans. Actually, sales were disguised as being loans, but by cutting and slicing and dicing things differently, you could actually disguise a sale as being a loan. And you could do it in the opposite direction, disguising a loan as a sales, playing on different laws that would actually allow you to pay less. As we know, there's an example. Another type of fiscal arbitrage is the case recently in the news of Monsieur Bernard Arnault, who, as soon as Monsieur Hollande, new president, and his Prime Minister Monsieur Hérault said they would change the law about taxation of the higher slices in the in the fiscal system, said, well, I'll move to Brussels and to Uccle, in particular. It is, of course, a paradox that in the Eurozone, where 17 countries are trying to have a common I say trying to have a common currency, that the fiscal unification has now taken place, and it allows people to say, well, I'm going to take to be for 1 hour and 20 minutes in the tallies, and different laws will apply. Interestingly, I saw that somebody raised the issue then in the following days at the European Commission of what would be done about it to prevent that from happening, and that the answer, there was actually no answer, well, there was an answer, but it didn't make any particular sense, and it didn't suggest in any case that any measures would be taken to prevent that. So that's called optimization, if you want to be an optimist, or it's called arbitraging, playing one against the other. Another interesting case recently was about Monsieur Eric Woerth in France, who was the minister of the budget, and it turned out that his wife was actually working on one of the most important, maybe the most important fortune in France, Madame Bettencourt, heir from the L'Oréal industrial empire, and that the wife of Monsieur Woerth, minister of the budget, I hesitate a bit because he moved at that period between two ministries, would be working on what she called optimization, but actually we're just trying to find ways to turn the law about the paying tax. I mean, the fact that the minister hadn't seen anything wrong in the fact that his wife was playing against the law is quite revealing of how popular these things are. Recently, another interesting case from maybe two weeks ago, 3 weeks ago, is from a representative of the ecological party in France, a lady who's in second. I think she's I don't remember the title exactly, but she's in one of the mairies in Paris, and she's number 2 in the line. And she was accused of laundering, money laundering through the drug industry. I mean the illegal drugs industry. And she defended herself, saying it was not at all, and her lawyer in particular saying that it was not a case at all of being involved with the drug dealing, but it was a simple case of tax fraud, of fiscal fraud. Fortunately, the leaders of her party told her it was not that better, and that she had to resign from the party. Loopholes, arbitraging different rules in different systems. There's something else which is called, we usually call moral hazard. And moral hazard is very much like something like similar to a financial instrument, which is called an option, and in particular a call option. And it's interesting, I think, to draw the parallel. If you buy a call option, what happens is the following. A call option, let's say, on a financial instrument, which the price of which is likely to move in one direction or the other. If the price, you've bought a call, you've paid a premium to somebody who's a seller of the call, if you wish. These terms shouldn't be taken literally, because I mean there are habits in the financial industry to call a buyer and a seller different types of people that would not be what we would call buyers and sellers, and that's because there's a tradition that anything that's long or short position corresponds to buying or selling. But anyway, so you go to a kind of somebody who more or less insures you by being paid a premium. And a call option is the following, is that if the market goes up, you receive all the money that's associated to the fact that your product has a value that goes up. But if it goes down under a certain level, which is called the strike price, if it goes down, you will not have to support the losses. The losses will be taken by the person who has assured you. And there's a lot of situations which correspond like to a call. Typically, a trader in a day trader in a bank belonging to a trading room is somebody who would get commissions on the gains being made, but would not see his salaries or remuneration, compensation being hit by the fact that he would make losses. So a trader receives a share of the money he's made to the company, but he's not being impacted by the fact of making losses. A big exception is the case that was in the news yesterday when Monsieur Jérôme Kerviel, when a company realizes losses are too big, then they may turn to the law and try to have the person to give the money back and even go to jail. But in the common working of the trading business for traders, they get commissions on the gains made, but they don't get deductions for the losses. What happens in reality is that if they're bad traders and that they make too many losses, well, they're being fired, and with some luck they can be taken by another company. But that's the way it works. So a trader has the equivalent of a call option. He gets money, a part of the money that is being made by him or her, if the value goes up, but he's not being impacted by the value coming down. Now, that call option situation has been very much in the news with the crisis, because that's very much what most of the businesses called too big to fail. That's exactly the situation they have been in. What happened essentially is that when they make gains, these gains would be distributed in terms of compensation for the main executives of the company. They would go to the investors of the company, but when there would be losses, the losses would be taken over by the state, and it would be actually the taxpayer who would actually be paying for that. Too big to fail was the nickname that was given by the press quickly. Now in the law and in different financial texts, they're called systemic institutions. Why systemic? Because they are linked. They produce a large amount of systemic risk. And what is systemic risk? Is the risk that actually the whole system would collapse if they let go, if they're not being supported. What was said in 2008, after the collapse of Lehman Brothers, the investment bank, is that any institution would be too big to fail, had to be dismantled, had to be broken down in units such that these units would actually not produce any systemic risk, that they could actually go into bankruptcy without a risk for the system as a whole. That was quite obvious. I mean, everybody agreed that these institutions had to be dismantled. But in the meantime, there's no discussion of that anymore. Lobbying bodies in institutions, sometimes lobbying using some of the money that the taxpayer had given them. The rescue process was used. There are some cases where the money used for the rescue was used by them for lobbying against their dismantling, and it has been successful. It's only at the only systemic risk measures now are at the level of the of some regulations, which, for instance, at the Basel measures that tell company to have some particular provisions or reserves on their operations. I think that there's one measure that has been added, asking these that these systemic companies, corporations, would have to add an additional, I think it's 1.5% to their reserves, which is a measure which is not, I don't need to stress it, it's not at all at the same level of, how would I say, of approach than demanding that they would be dismantled. A moral hazard is, as you understand, that's a phrase which can be used apparently since the 18th century. It was used first for the insurance companies that would support, that would actually insure, like for big traveling, for expeditions that would go to the West Indies or the East Indies, trying to come back with spices and so on. There might be, if you have a very high insurance, of course, that you might be incited to, how would I say, to exert it by asking for, people to attack the boat or things of that type. So a moral hazard is an incentive that develops from the situation to behave dishonestly, because you know that the risk is actually taken by another party. People would say that in the insurance business, there's out of necessity moral hazard, in terms that you may say that if somebody insures his car, he may automatically feel a bit more reckless in the way in driving it, knowing that he or she is insured. I don't think it's possible to remove entirely all the dimension of that type to this type of situation. The phrase that was used by a journalist to describe that situation when it applies to corporations was privatization of gains, socialization of losses. The company and the people, the investors, the executives share the money when it's made, and if the company is too big to fail, then they are not hit at all by the losses which are taken over by the community. Another domain in which there is a lot of difficulties linked to contradictions in the system is when there are rules, but they are actually inapplicable. They cannot be applicable, or they can be only applicable very, very partially. All the cases of insider trading are more or less of that type. It seems going without saying that in a business, knowing what's going on is a major advantage, and that you could not be penalized for knowing what's going on. It's part of your business, and if you don't know what's going on in your business, well, I mean, you won't be able to run it at all. So, if you know, for instance, that there will be an interesting move in your company, that there'll be a merger, or that you found a new product and so on, it would be very tempting for you to buy shares in your company or company in advance, knowing that the value will go up. This is actually forbidden to do so, to act in that particular way. There are rules. I mean, they're different from country to country. Who it applies to and who it doesn't apply. The American law is particularly stringent on that. There's been a famous case about 10 years ago with Martha Stewart, who was a personality from television. She's a person who is very well known for advice on cooking and home decoration and so on. And she had received a tip from one of her friends, and she had bought shares in that, following that advice. And she went and ended up going to jail. It was very much felt by the opinion. It was a kind of, how would I say, an example being made because she was a personality, although it happens all the time. And the law is not very consistent about that, because there are a lot of exceptions. It doesn't apply, it applies to shares, to stock, but it doesn't apply, for instance, to the market of commodities. Commodities are, like things like metals, like gold, copper, zinc. They are food, like grain of different type. There's cotton, cocoa, coffee, and so on. The reason why the legislation is not there so stringent about insider trading is that it seems like the business would become totally impossible if you could not really take advantage of the knowledge that you have. The law applying to insider trading was changed, was introduced in Japan relatively recently. I think it was in 1999 or something like that. But there was a lot of resistance locally, saying that it was nonsense. That how could you possibly not take advantage of the things that you know? Milton Friedman, who was a friend of ours because I cite him in nearly every lecture, was of a view that there shouldn't be any insider trading prohibition. That you know, it was very much of that school of economics where it is regarded that information, that how would I say, that price is really created at the right level by the fact that the information circulates about what is the actual value of something. There was an interesting case, I don't remember in what years it was, maybe it was again something like from 10 years ago, where there was an attempt to introduce futures on terrorism on the American market. The idea was the following. The idea came from Mr. Poindexter, who had been very much involved in the Contra so-called scandal. But at that time, he suggested the following, is that there should be futures on terrorism. People would actually buy and sell a product that would be indexed on terrorism acts happening. And the idea was very much, I would say, Friedmanian, Milton Friedmanian, was that the market knows what is the actual value of something. So the idea would be that if somebody knows about some terrorist act being about to be performed, that person would buy some future, be long on a future, would try to make money if there was one of these acts being performed, and that therefore how would I say, the defense community could actually by monitoring the prices of these futures, being able to have some pulse of what is the situation, where there's any risk being taken or not, whether there's any information circulating about something, some terrorist act that would be performed. The public did not understand at all the concept, and it was actually withdrawn because there was such an outcry in the public that there would be some kind of incentive for people to possibly, buy some long contracts on some terrorist future and actually have it performed in order to get money. It would be an incentive to do it. Like the images used for some credit default swap, when you have what's called a naked position on credit default swap, you can insure yourself against a risk which you're not actually taking. These credit default swap have been very much mentioned as being elements that possibly led to an exaggerated reaction to the difficulties of Greece, Portugal, Ireland in the market recently, because people could insure themselves on losses on debt instruments of Greece, Portugal, Ireland, although they did not have it. It was regarded that there's a moral hazard there. The image that was used, it was insuring your neighbor's car. If you can get an insurance on your neighbor's car, you will not be too, how would I say, you might be very careless about what happens to it, because you benefit from what happens to it in different circumstances. So therefore, that inside trading laws, this idea that you could that you cannot, in many circumstances, you cannot use the information that you have, it's a type of the contradiction that I would say leads to difficulties like automatically. Another type of inapplicable rule is self-policing. It is very common in the financial world that institutions are supposed to be self-policing, that they have to look themselves, make sure that they do not go into difficulties. But self-policing at the same time, although however popular it might be in the financial world, is a typical type of conflict of interest, of it's something which is impossible. It's not for you to supervise your action in terms of whether it's right or not, because you will be out of necessity. You will be lenient on yourself. You will not be harsher on yourself than you would be on somebody else. The justification for that is in terms of expertise in terms of expertise, that a company is actually the best expert about its activity, and that therefore it would know exactly where it can possibly go wrong. I'll tell a little anecdote in that respect, which is that I was asked to testify at the European Commission. It was 2 years ago, something like that. There was a committee about the origins of the crisis, and 8 experts had actually been asked to come and testify about the origin of the subprime crisis. But I was very surprised that out of the 8, 7 of them were actually representing either a bank, a specific bank, or representing a particular nation. And these testimonies, which were supposed, of course, to be objective and giving a fair representation of the situation, were actually a plea in most cases, a plea that sometimes even sounded like a publicity prospectus for their own bank, for the people who belong to bank. Or there was a representative of Britain who was actually reading a message from her minister. How could that possibly be, how would I say, an objective or fair view about the situation? Because by necessity, these people would insist on the fact that there was no responsibility on their part. The funniest aspect of it was probably that I had been invited to, but I was told later on that it had been extremely difficult to get me in the panel, although I was probably the only one who really met the description of the person that was supposed to come to a meeting like that. Another example of conflict of interest was the recent Libor cases. In the case of the Libor, the Libor is a set of rates linked to different maturities. A maturity is the length of time after which a loan comes to an end. So the maturity of a particular loan can be 3 months, 1 year, 2 years, and so on. And in the way that the Libor is set, which is a rate which applies to the loans that banks give to each other, it's the interbank credit industry market. Banks were asked the following: how much do other people, do your counterparts on the market, how much do these your colleagues, how much do they ask you as a rate on a loan of a particular maturity? And of course, as you understand, that the loan which is required from a company reflects the confidence, the trust that other banks have in that company. So a company has to give a figure which reflects the trust that the others have in them. And that's like a bit like, I would say, again, it's an encouragement not to say the truth, because if people don't trust you, they will ask for a very high rate, and therefore, if you say that, that will be known by the others that actually that there's no trust towards you. And in the period in 2008, which was, of course, a period of chaos, companies had a tendency to lower the figures compared to what they were actually asked by their colleagues, the other people in industry, and that seems like a normal reaction. You don't want to give a bad view. You don't want the stigma of having to say that other people don't trust you. And when there was a committee in Britain discussing the issues of all the cheating that had been that happened at the time, there were some views being expressed that maybe in the heat of the crisis, that maybe even coming from high up from the government, there had been suggestions not to have these rates being quoted as too high, because they would have suggested that the industry was in real difficulties. What turned out to be the case is that very much the figures that they were quoted by these banks were actually discussed in the trading rooms by the traders, and what would be nice for us tomorrow to have as a figure, and that these figures they would transmit it would not at all reflect the actual situation, but would be made up in order to benefit the business of the company. recently the Barclays Bank has had to pay a very heavy fine precisely for the having distorted the these figures. But it's not the only company. There's a lot of them. Out of the 16 which are involved in quoting these figures, a lot of them will actually have to pay fines or being even indicted on something more precise for manipulation of the prices. I could go on with examples of that type. What is the possible redress to a situation like that? What can actually be done? And because as you see, I mean, there are some contradictions in what I've mentioned, which are kneeling, I would say, are not linked to really people being virtuous or vicious. They're very much linked, I would say, to the world within we are, linked to the physical nature of the world, linked to the very nature of the human being, that some situations out of necessity will be conflictual, that there will be contradictions in situations, and that people will try to benefit in one way or other. My suggestion of how to deal with that is that there's something that we call the spirit and the letter of the law. The law is written in one way, and it's the text, of course, the way it is actually written, the meaning of all the individual words, the way the meaning of these words will be combined in a particular sentence is something that, of course, will be essential for the decisions made by courts if there's any contest about what is actually said. I would say that's the letter of the law. But there's something which was the intention of the people who wrote the law, or the legislator, and that is quite easy to find out in most cases. In the cases when there are loopholes and people try to turn the law and so on, it would be possible to remind them that it's not only the question of the letter, what the meaning of the words, and I would say the contradictions which may have fallen between the cracks of the words in the sentence, but that there was an intention from the legislature, and that intention, the spirit of the law, is the thing to concentrate on. And thinking about that, I believe that the higher up you go into the writing of the principles that you want to have applied, like typically the highest level would be that of a constitution or of some international agreement like the Human Rights Proclamation, things of that type, that if you, in text of very valid, how would I say, wide application, with very simple sentences saying exactly what you intend to do, like saying speculation is forbidden. If you say, let's say in the Constitution, speculation is forbidden, it's more difficult to go to court later on and to say, well, there's a slight contradiction between that article and that other, because the Constitution says, well, no, speculation is not admitted. There's a higher principle that trickles down, I would say, through the whole system. And this is the reason why I back in 2007, the very beginning of the crisis, in a opinion piece in Le Monde, I asked that there would be that people should work on something that I was calling a constitution for the economy, but what I meant was an international constitution for the economy that would remove a lot of these difficulties linked to contradictions that we know we cannot eliminate entirely, because there's no way that can actually be done, because as I said, some of these contradictions are linked to the very fabric of the world and within which we live, and of the very way we are as animals that live within that world. So the higher up you put the principle, I think the easier it would be then to have to remove some of the inconsistencies that would automatically appear. One thing that cannot be dealt with that way, or it's more difficult, is to prevent lobbying against the constitutional articles that would then prevent them from being even there, because that principle I showed, that was the required amount of money, you can prevent things from happening as far as the law is concerned. And the example about the sugar industry was I would say a very illustrative one. it is possible indeed to prevent that things are being taken one direction or the other. Of course, there are movements in the opinion. There are reactions. I mean, yesterday we had a very good example when Mr. LeCun, the governor of the National Central Bank, came up precisely with some of these very high-level principles about things that work and things that do not work. And so it is possible to have these views, how would I say, advertised, to have them promoted, to work from them, to work in the public opinion in order that these higher-up principles are being instated and become the way we work. Because we know of the accidents that may take place. It is a pity that when people like in the case of the capital markets, the money markets, when people work for, I mean, some very dedicated people work for 5 years to find the principle that would prevent a particular type of crisis to develop, that actually then, I mean, that the power of money prevents these measures from being taken. And when I say the power of money, I mean, this is not some plot theory. The Wall Street Journal is a journal which is linked to the financial industry, but they are very good when a decision of that type is being taken or not being taken, to advertise how much of the different people on the committees have received, how much money they have received individually from the industry. And in the example I mentioned of Mr. Stern, his article about the sugar industry, he has a table. He looked through the contributions to the political election of these different politicians that were involved in removing or not these subsidies, and he shows that those who had received above $5,000, at 100% of them had actually voted against removing the subsidies. Those who have received a little less money had, the percentage was coming down, but there was a very clear. However much people may say, well, I received that money, but it doesn't influence my judgment, which is usually the explanation they give. The figures show that that was not the case. We will do like we say when there's a panel, which is that we will have a short interruption before the panel actually starts. But before we do that for 5 minutes, I would turn to you and ask if there's any questions on what I've been saying today. I'll take 2 or 3 questions, not more than that. And if there's none, then we can have the interval, the break, right away. Any question? All right, well then let's take the 5 minutes.
We just came in, but I suppose that the formulas are not yours. What's written on the blackboard is not.
Oh, Michel, I won't restart for you. I'm sorry. No way. These are pretty complicated. We spent a lot of time on them. And,
thank you.
And as you know, I mean, the difference between Bernoulli actually and... anyway, so 5 minute break.